Good morning. May it please the court. If you're ready, I'll go ahead and start.
Go right ahead.
My name is Michael Park. I'm here on behalf of the appellant David J. White. We're here basically on a relatively simple, straightforward issue, which is the denial of my client's attorney's fees and costs in a supplemental petition for approximately $36,000. The facts are fairly straightforward. The parties have submitted financial affidavits which the court relied upon. The lower court took evidence and made findings with regard to incomes and then made a determination as to the fee. And I'm going to read the one critical paragraph that the court made. I think it's in paragraph 10 of the supplemental final judgment. This is page 1648 from the record, because I think this is very important. Previously, the court found the incomes of the parties and found that the former wife, made approximately $121,000 per month, and that the former husband, that's gross, the former husband made approximately he made $8,441 per month gross. And then
Always seems to take a big issue with it, but was this 1 year income sort of unusual?
that's not what the trial court found. Yeah, and what we're here to deal with is obviously the findings of the trial court. That's not been appealed, that's not been disputed, that's a factual finding. And under the abuse of discretion standard, obviously this court has to take that as, with great deference to the trial court, and since the other party didn't file an appeal of that, it's kind of settled. I mean, we're both operating under the supplemental final judgment and the findings of the court, which are now basically undisputed on appeal, which are, this is what her income was, this is what his income was. Needless to say, even if that were not true and you took out that bonus income from 2016, she still has far superior income to him. I think that the income on her financial affidavit, which I have right here, which is the one that was filed into evidence in October 2017, she lists her present gross monthly income at $25,000. So it's still 3 times the amount of the former husband's. But if you look at her 2016 tax return, which is what the lower court did, and you look at how much money she made, and the court made a specific finding that she continues or has a habit of doing these types of purchases and sales and making this type of income, it is well within the purview of the trial court to find that that's a continuing income based upon Chapter 61, which defines income very broadly. So my point is, regardless of whether or not you include that income, you still have a vast disparity in income. Getting down to...
He is not without assets himself.
That's correct, and I'll get to that, because that's that is probably the critical question in this case. If you look at the supplemental final judgment where the court makes some additional findings in the child support, where it basically goes through the tax calculations, it finds essentially that the former husband's net income, which is what really is important here, is $6,744.19, and the former wife's income is $74,208.10 per month net. That's critical because if you look at their financial affidavits and you look at how much income they have based on the undisputed findings of the trial court and what their expenses are, my client is upside down $2,000 a month. His expenses on his financial affidavit, which there was no really dispute over, was about $8,800, so he's about $2,000 upside down. The former wife's expenses were around $30,000. Her net excess after taxes, after paying all of her expenses per month based upon the undisputed findings of the trial court, is over $40,000 a month, net after taxes. Now, paragraph 10. The court finds that based on the fact that the former husband has a gross income of $8,441 a month and that the former wife has a gross income of $121,130 per month, and here's the critical part, and that both of these parties have significant assets. The former husband has less assets, but there is still a ranch and there are horses and a rental property and so on, so it's still considerable assets in the opinion of the court, and therefore there will be no award of attorney's fees either way to the former husband or to the former wife. That is not sufficient findings. Those aren't sufficient findings in order to deny a claim for fees based on these facts. The court doesn't go through any analysis of what are those types of assets. Are they liquid? Are they illiquid? The court goes through no analysis of how much more assets she has versus what he has. The court doesn't go through.
There was a recitation of the nature of the property that he held out in Oklahoma.
Mm-hmm. Yes, sir.
Okay.
There was. And that's important because, as I said in my brief, he owned two pieces of property. He has his homestead, which he owns jointly with his wife, his new wife. So he couldn't sell that, encumber it, do anything unless she agreed to it anyway. It's held joint tenants by the entireties with a non-party to the litigation. And he held a rental income, which is where he made the vast majority of his income. He also has a plane, and he takes people up on rides, and that's
Isn't there, the ranch is liquid, but doesn't he derive income from it?
I believe the income came from the rental property. And I'll have to, honestly have to go back and look, but my point was that the property or the assets, and on his financial affidavit, which is the only thing we really have to go on because the court didn't make any specific findings about assets and how much they were, so we have to rely on the financial affidavits entered into evidence. He's got, I think, around $650,000, $640,000 worth of assets, which are encumbered to the tune of about negative $400,000. So he's in the hole based upon about $1 million worth of debt that he has, most of which is carried on these properties. And the court, in making the finding about his income, he's got $8,000 in net income, it's utilizing the income derived from these properties, which she says he can use to pay fees. So on one hand, she's saying he's got this much in income, and on the other hand, she's saying but he can pay his fees, but in order to do so, he's got to liquidate the very assets she's relying upon for the child support income, which you can't do.
Now, he had already paid most of his fees, am I correct?
I don't know personally, I don't know what the outstanding fee was due and owing. I don't want to go outside the record because
I understand.
I know what he has had to do to pay fees, but that's not in the record, and I don't want to bring it up. So, getting back to the, I'm sorry, I'll reserve 5 minutes for rebuttal. Okay.
I figured you would.
Yes, sir. There's this continuum in Florida law, and I actually have struggled with this for almost 20 years when it comes to attorney's fees under Chapter 61. And you have this continuum where you have cases like Lohman, Anselou, and Castor, and some of these cases which basically say if there's a vast disparity in income, which there is in this case, it's an abuse of discretion not to award all the attorney's fees to the party who's in the inferior financial position. Then you have cases on the other side, which, like Blaine, some of the cases I've cited, which basically say even if there's a vast disparity in income, if the parties are on relatively equal financial footing and assets and everything else, it may not be an abuse of discretion to deny fees altogether. So we've got to find the thread that kind of runs through all those cases. And in reading all the cases and trying to find that thread, the one that really sticks out to me is looking at the impact financially on the party asking for fees and what happens if they have to pay their own fees. So in cases like Blaine, where a party has substantial assets that are liquid, and they can essentially pay their own fees without substantially impairing or harming their assets and or having to pay out of their current income, which would take away from their standard of living and impact them there, then it's not an abuse of discretion if it basically has no really financial impact on them. In the other cases, where you have a substantial amount of assets, or you have assets, but you'd have to liquidate those, and that would materially impact your standard of living. It would materially impact the equitable distribution you got in a dissolution case or something like that. That's where the courts have said, no, you don't look at that. You look at the vast disparity of income, and that's more of the Lohman-style cases and its progeny. So we have to kind of look at that analysis, and I'm happy to take questions about that, because that's how I read the cases. That's how I've been able to kind of put those cases together in a continuum and say, okay, how do I make Blaine reconcile with Lohman? And the case is similar to Blaine and Lohman. So that's how I see the law developed in this area of attorney's fees. So using that lens, we have to look at the case and say, okay, what are the types of assets that the former husband has? And if you look at the financial affidavit of him, which is what we have to rely upon, as I said, he has about $624,000 in assets, and his listed liabilities are $1,026,000. So his net value is negative $400,000. Now, looking at the other assets, that in of itself is going to be a vast disparity versus what the former wife has, which depending on the financial affidavit you look at, I've said $7 million net or gross assets in her one affidavit. I think the other affidavit at trial was $9 million. So her net assets are between $5 and $7 million, depending on the financial affidavit, and her liquid assets are substantial. I mean, she's got cash, I think, is $140,000 sitting in a cash account. She's got retirement of $500,000. She's got, I think, an IRA of some money. So it's not illiquid. And my client's entire assets are basically used to either live on with his wife, current wife, not able to be encumbered without her assent, their rental property, which is driving the income, or it's his airplane, which has a $120,000 note on it. So to require him to use any of his assets, I think it's like $1,300 in cash as of the financial affidavit. So to require him to use any of his financial assets to pay the attorney's fees would either require him to get his wife, who's a non-party, to agree to it, which there's no evidence she would agree to it, can't do that. It would require him to liquidate the rental property, which he's deriving the income, which the court uses for purposes of child support, and you'd have to go make a change to that calculation, or he'd have to, excuse me, sell his airplane, which is basically upside down, which also the court found made $1,000 as for the income for the child support. So there is no ability that he really has to get liquid assets to pay these, and anything that he would have to do to pay these $36,000 in fees would require him to materially impact his income and or his assets, and there's no need for it. Let me be clear, the former wife's, based on the findings of the trial court, the former wife's after-tax surplus each month is more than what we're requesting in attorney's fees. She could stroke a check from her surplus in any given month that she has. So this case is much more akin to Lohman than it is to Blaine. And based upon that, we would request that the court reverse and remand this to the trial court with instructions to find entitlement to fees and to find, and there's no dispute that the $36,000 was reasonable in this case. So to pay 100% of the fees, and we would also request, we've asked for attorney's fees obviously on appeal, we'd also request that to avoid an unnecessary appeal again, that you'd find, you'd Rados remand it back and also find entitlement and have the court establish the necessary amount of fees on appeal after we prove the reasonableness of what we've done. Unless there are any other questions, which I'd be happy to take, I'll reserve the remainder of my time.
Thank you, Mr. Park.
Thank you.
Good morning. It's a pleasure to be here. Kim Kashuba on behalf of the appellee, the former wife, Vonda White. May it please the court and counsel. At first blush, former husband's counsel would suggest this is a simple, straightforward case of need and ability to pay to entitlement to the former husband, which was denied by the trial court. But this case and the facts surrounding this case are anything but simple. Mr. Park referenced that, well, yes, there is some income that Mr. White derives from a rental property. In fact, those rental properties are not just one. There are, in fact, a large shop, a small shop, a storage, a warehouse apartment, a barn warehouse, 2 buildings, and several pastures to the tune of 1, 2, 3, 4, 5, 6, 7, 8, 9, 10, 11 tenants that equate to over $9,300 a month in rent that was collected. That's contained at a summary at the record at 636 in former wife's exhibit 15. The additional items that were reflected as part of the record is that this horse ranch that consists of, yes, 40 acres, 6 horses, which, by the way, were not listed on his financial affidavit, the marital residence contained on there, and a next to almost complete constructed business park referred to as Cordon Business Park. The ranch itself is referred to as Terre Blanche. If the court looks at the record at approximately 1524, former wife's exhibit 34, the bank statements reflected from Terre Blanche for RCB Bank show that as late as August of 2017, $44,999 were deposited in that account. The prior month, $32,985 were deposited into that account. The month prior to that, $15,354 were deposited in that account. And this is prior to the business park even having been fully constructed and operational. And at the final hearing, the former husband attested that that 4,000 square foot complex should generate approximately $3,000 and was almost completed. The other discrepancies, which I might suggest to the court, were flagrant on the part of the former husband, is that he simply listed, even on his latest updated financial affidavit, $133 in Social Security disability income. He neglected to mention the rental income until such time as the leases were generated by virtue of our request for production. He failed to list the World War II biplane, which on his testimony, he admitted that he earns $10 a minute, or $1,000 in one day for generating plane rides and flyovers utilizing this $150,000 asset. Part of the former wife's exhibits 32 and 33 show that there are a variety of cash deposits that were deposited into the RCB White bank account, which equated to $12,000 just in 2017, or $1,500 a month. That's one account. The other White family checking account shows cash deposits that were undisputed of approximately $51,000 over the span of November of 16 through August of 17 for a total monthly of approximately $51.55. So there is a variety of discrepancies in the income and this suggested need by Mr. White for the former wife to pay his fees. Additionally, I believe Your Honor LaRose asked or suggested that were almost all of his fees paid at the time of the final hearing. The trial transcript, Your Honor, at 158, under the testimony of Mr. Thacker, he admitted that as of right now, Mr. White owes me just over $11,000 in outstanding fees. So the court is correct. The $35,000 that is or being requested by the former husband was predominantly paid up into the final hearing. And the evidence presented at the hearing suggested that former wife's, again, Exhibit 39, the record at 1610, suggests 1610 through 1613 that his Visa credit card was predominantly the account that was used in order to pay for the attorney's fees. And as late as August of 2017, the most recent statement that was provided from him to us suggests that the $11,000 payment to the Visa credit card almost nearly satisfied, but for a couple $100, that credit card bill. And in his cross-examination, he admits that his credit cards are customarily paid on a monthly basis. He has not indicated that he has had to. He stated that he did not have to take any loans in order to pay his counsel's fees. And one of the recent cases that I supplemented the court's record with, the Sarazin case, in the 4th DCA from February 9th of 2019 suggests that in that case, the wife was predominantly getting paid gifts from her family, and she was denied fees because there was found to not be a need when there was no suggestion that any of those fees or the obligation to repay back her family was present. And that's essentially what is being argued by the former husband, that he's having to rely on his current wife, who is a nurse anesthetist and makes decent money at $170,000 or $200,000 a year, but for her supplementing these expenses, he would not have to pay for it. And I would suggest the record reflects otherwise. There is no note or obligation that he in fact owes her that money. His credit card statements are paid on a monthly basis. He barely owed $11,000 at the time of the final hearing, and his bank account statements suggest that he clearly has greater income than is being suggested both in his financial affidavit and then simply from his rental properties. There's no dispute that the former wife does in fact own more assets than he does. But former husband would suggest that his financial affidavit points out to a deficit of $400,000. And I would ask the court to take a look again at that financial affidavit, because the assets, in fact, that are listed in there are listed as 1/2 values. And the liabilities that are listed, 1/2 because he suggests that his current wife owns the other half of those assets, whereas the liabilities that are listed are 100% of the value. And when you take then apples to apples, he actually has a surplus to the tune of close to $300,000 in assets, as opposed to a negative $400,000 that is being suggested on the former husband's behalf. But what I'd like to raise to the court are the two alternate arguments, okay? We believe that the need, or the lack of need, that was found by the trial court judge was absolutely appropriate. Under Rosen, not only is the court to look at need and ability to pay, the court is required to take a look at also the facts and circumstances surrounding the case, the scope of the litigation, whether any of the litigation is intended to frustrate or stall or delay, and this is in fact exactly that case. This is the case of a former husband who took 19 months to not pay any child support to the former wife, who was ordered to pay arrears of $19,000, who was ordered to pay outstanding past due medical expenses of $14,000, and who was found to have been in non-compliance with the marital settlement agreement by not doing so to the tune of $29,000.
Can I ask you a question about that?
Yes, Your Honor.
You cited section 6116, but that's an outright prohibition on fees incurred, I believe. That's why I read it, incurred for the purpose of bringing an action for enforcement. So in other words, if these fees were incurred in those, toward the end of getting him to comply with his orders or his agreements, then it would be an outright prohibition on fees, and we wouldn't be talking about any of this. So how does that relate to fees, which I'm assuming were not incurred in motions for contempt or in motions for enforcement, but rather incurred in other parts of the litigation leading up to this equitable distribution?
Let me see if I can answer your question twofold. We believe that the statute does preclude the entitlement to attorney's fees by the former husband because he was non-compliant. At the time the parties entered into the marital settlement agreement was in 2004. At that time, there was no requirement that there be a step down in child support guidelines, which in fact would require that after one child emancipates and there are remaining children, that the amount is already calculated, say, for child number 2 and child number 3. That was not present at the time they entered into this. At the time, the former wife filed both her supplemental petition as well as her motion for contempt. The former husband had been delinquent over a year, and there were 2 remaining minor children. There's evidence in the record in communications between counsel pre-litigation that said where he stated on the former husband's behalf that nothing was owed, but for the fact that there were 2 remaining minor children, no step-down provision or determination of the amounts for childs 2 and 3. Ms. White may not have had to have filed a supplemental petition to establish child support, which was obligated under the marital settlement agreement. He was obligated to pay for 3 children. The amounts were undetermined. So she could not avoid having to file an action to seek to establish that, but for his noncompliance and refusal to pay anything, not even $50 or $500 at that time. When the eldest child reached 18, he stopped paying $0. So it's our position that not only did she have to file the contempt and enforcement for past, she also had to file the supplemental petition for compliance for current and due and owing children based on the lack of step down that has now been cured, thankfully, for those of us family law practitioners as well as the court that can appreciate we don't have to come back and argue unnecessarily to establish that unless there's a modification. Now, with respect to the contempt fees, I believe Mr. Park indicated that there was no dispute as to the amount of $35,000. Well, in fact, the record will reflect that I did raise arguments about the fees that were being sought. The totality of the fees sought by the former husband were $44,000. I clearly indicated that some of those fees, and my argument, in fact, was at the trial level that $23,000 of those fees, which were sought at the time of the contempt when the former husband filed a motion for temp fees, $23,000 was being sought, and therefore those fees at that time should not be included within the totality, leaving a balance of roughly $21,000. Former husband's trial counsel, Mr. Thacker, indicated his records and his calculation were that only $8,300 or thereabouts should be deducted, which is where the $35,000 amount is suggested to be still due and owing and being sought. Of those fees, whether it's the $35,000 or in my view the $21,000, there was approximately 4.15 hours or approximately $1,225 that Mr. Thacker admitted on the stand were associated with appellate matters and therefore were not coupled or part and parcel with the underlying lower court's proceedings. So there would be another $1,225. But all in all, the testimony was that at the time of the hearing, approximately $11,000 was owed, that the credit card bills were being paid, that in fact that there was no loans outstanding for fees that he owed his counsel. The alternate argument, and so getting back to 6116 and the non-compliant party, I truly believe that this is a case that this court can set and write an opinion on and set precedent for the better understanding of what a non-compliant party is that I believe our family law jurisprudence needs in the state of Florida. So much so that I was speaking with a colleague recently about this argument, non-compliance, and he's been practicing longer than I have, has been before this court a numerous amount of times, and had to say, where did you find that? Where does it say non-compliant party? And I said, take a look at 6116. We very seldom hear that argument. It's very seldom used. But this case and the underlying facts, I think, cry for a decision that non-compliance should not allow a party to go before a court and ask for fees when they, in fact, have come with truly unclean hands. The third alternate argument, certainly that we encourage the court to also consider, is the inequity. And the case of Bain does mention that. In Bain, the Florida Supreme Court indicated that settlement agreements and the contents within the settlement agreements should be upheld, but fees, in the sense, shouldn't necessarily be looked upon to dissuade that party that, in fact, is trying to uphold an agreement for fear that they will face or suffer, if you will, the payment of fees because they've got greater assets. And that is essentially this case. And essentially one of the reasons why the former wife has elected, although she certainly, in my view, may have grounds to have elected to appeal some of the decisions of the trial court. She elected not to appeal the issue that there were no interest to be paid on outstanding child support arrears or the unpaid medical expenses, or the fact that he has 10 years to pay $14,000 for the unpaid medical expenses, or $200 a month, calculate that out for $19,000 in arrears. Those are items that she did not want to argue because she knew that all she's going to do is continue to incur more fees. And all she was wanting to do was appeal her children's rights to have their father pay for what they truly were entitled to. And after 19 months, she made the decision, well, it wasn't 19 at that time, because 6 months of his unpayment occurred even during these proceedings. His first payment was in October of 2016, and we filed in May of 2016. So that shows you his clear willfulness, if you will, and refusal to pay anything or support. And part of the other reason for the modification proceeding was that not only the child support, but he wasn't exercising the time sharing with the children in accordance with the original marital settlement agreement. So she was seeking to simply which ultimately required her to continue to support her children even more so, because they were with her greater of the time, to rather solidify a time-sharing schedule and overnights that would account for the fact that he no longer was in the area. He moved clear to Oklahoma. He wasn't exercising time-sharing, but seldom, and I believe it's approximately 14 overnights per the year. And so ultimately, we believe that although she has greater assets, the amount of assets that the former husband has exceed $1 million. He lives a lavish lifestyle. He has no need and hasn't taken any loans or required any other obligations in order to meet the need for his counsel's attorney's fees. This is not a case where he has so little income that he can't afford or barely can afford counsel. He's hired counsel that is a family law practitioner for the trial level. He's been able to hire 2 appellate counsel, Ms. Grossman in the first case and now Mr. Park in the second case. And there's nothing to suggest that there were any loans attributable to those. He has not been compliant clearly under 6116, we believe, because this entire action was necessitated by his refusal to want to support his children, to pay his wife that which he was entitled to, and ultimately, in equity, we believe that it would be unfortunate if a parent who is the obligee in this case, Vonda White, would be required to now give back essentially that which she's been awarded. She's been awarded a totality of $60,000 under the original order that this court upheld, consisting of the arrears, the medical expenses, and approximately $29,000 of attorney's fees. Now, the former husband's seeking $35,000 in attorney's fees, so he wants to be recompensed for the $29,000 he had to pay and to pay him another $5,500. It just does not seem equitable or fair. And in light of that, we would ask the court that it find that he not be permitted to seek appellate fees, that his motion for appellate fees be denied, and rather that the former wife's motion for appellate fees be granted and remanded to the court for a determination of the entitlement as to the amount. And if the court doesn't have any other questions, I'll...
Thank you, Mr. Chairman.
Thank you.
Well, I must say that was a masterful job of talking about everything but the issue on appeal. We talked about evidence that Ms. Kasuba and her client would like to have had the court make determinations on. We talked about a whole bunch of expenses and bank accounts and income to my client, which she would like to have the court made findings on. The fact of the matter is the court didn't make those findings. And Ms. Kasuba and her client did not appeal any of the findings of the trial court. So they can't come in here and say, oh, well, but see, he has all this other income, and therefore he's not entitled to fees. The fact of the matter is the trial court made specific findings regarding incomes. The trial court made specific findings regarding her income and his income based upon the disputed evidence at the final hearing. She can't now come in and argue that it should be something else without appealing that issue herself. So the vast majority of her argument is predicated on you substituting your judgment for the trial courts and making alternate findings that the trial court didn't make. Now, the big issue here is on the substantial disparity in the assets of the parties. And that's where she said, oh, well, he's taking credit for 100% of the liabilities and only 50% of the assets. Well, if you own things jointly, you basically have 50% of that. And maybe, you know, this is an interesting question because on one hand, he owns something with joint tenants as entirety, so by law, he owns 100%, his wife owns 100%, but he can't encumber it even if he wanted to. He can't, it's not like a tenants in common, where you can encumber your 50% or whatever else. He can't do it even if he wanted to. So it doesn't matter whether it's worth $2 or $20 million. If you can't encumber it, he can't get money out of it. It's illiquid. He can't sell it, he can't encumber it, he can't get a loan from it. And he is on the line for 100% of those liabilities. If he's signed on to a note and mortgage jointly and severably, then the bank can come after him 100%. So it's not unfair to put that on the financial affidavit the way he did. Regardless, it doesn't matter. She's still, even if you say he's got $1 million, take away his liabilities, they're still non-liquid assets. They're still what he relies upon to live on and what he relies upon to generate income. And the former wife still has 7 times that. So there's a huge disparity. And once again, getting to the income levels, she can pay in 1 month's excess all the fees he's asking for. Now, getting to this question about the whole idea of 6116 and a non-compliant party, we are really far afield. The first appeal, the first case was about the contempt. The first thing we're dealing with that was already dealt with. That was already taken up on appeal and dealt with. This is on the supplemental petition, which is completely separate and distinct from the non-compliant argument. So what she's asking you to adopt is, if a party is at any time non-compliant with paying child support, they're forever stopped from asking for attorney's fees for any other legitimate reason. That's simply not what the law is. It's not what the law is. By the way, the case law basically says, under a motion for contempt even if you're the contemnor, you still have need and ability analysis to do in order to figure that out. So even if you're in contempt, it doesn't automatically mean that the other side gets attorney's fees, which is what she's asking for. There are cases, Hahamovich and other cases, which basically say, if you have a superior financial ability, you cannot get fees under 6116 or Rosen. You have to use the inequitable conduct doctrine. So her client can't get fees even if she wanted to, because the plain findings of the court, she's in a vastly superior income position, vastly inferior asset position. So asking to reverse and remand with an entitlement for her fees runs afoul of all Florida jurisprudence. Moreover, it's not necessary, and I heard, oh, well, he can pay because he didn't take out loans and everything else. Well, if I want to go outside the record, I can tell you a whole bunch of stuff about loans he had to take to pay fees, but that's not in the record. I'm not going to go there. And case law says it is not necessary for a party to not be able to pay any of their fees or all their fees in order for them to be entitled under 6116 to attorney's fees and costs. That's the plain black letter law, and it's been repeated over and over again. Otherwise, any party that can contribute whatsoever, even if they take out a loan or get something from a family, if they pay any part of their attorney's fees as an initial retainer, which everybody does in family law, as this court well knows, that would then be an estoppel for them to get attorney's fees, and that's not what the law is. That's why we have a need and ability analysis that the court has to do. The court made specific findings in this supplemental judgment we can't get away from. In paragraph 5, talking about the issue of contempt versus the supplemental petition, this is all about the supplemental petition, and the court says the court finds a substantial change in circumstances exists that warrant modification of the final judgment. The court found there's a supplemental petition pending. It was warranted. They filed one. My client filed one. There were circumstances which existed, emancipation of the minor child. The settlement agreement set one number. It has to be changed. So basically the court granted the relief that was requested. And regardless of whether or not you believe that my client won or lost that battle, that has nothing to do with 6116. This was not an enforcement proceeding. The fees claimed here are not for contempt or anything like that. They're for the supplemental petition. And under that analysis, you have to look at 6116. And if you look at the case law, as I've suggested, Blaine versus Lohman and its progeny and everything in the middle, you've got to look at the assets available. You've got to look at the type of assets. You've got to look at the liquidity of it. You've got to look at the impact of using those assets to pay your fees. You've got to look at the incomes. And when you look at that in the total analysis, based upon the plain findings of the trial court, which we can't get away from, the former wife has a superior income, vastly superior income. The former wife has vastly superior assets, and it would negatively impact and be impossible for my client to liquidate assets to pay these fees in order to continue paying the child support that he's been ordered to pay based upon the income that the trial court found from the rental property and from the airplane and all the other assets. So based upon that, as I said before, I would ask that you reverse and remand this decision with instructions to the trial court to make a finding of entitlement and to award all the reasonable fees and costs associated with the supplemental petition as we've been asking for, and also find an entitlement for appellate attorney's fees based upon that, and have the courts establish the reasonable amount of those fees. Unless there are any other questions?
Thank you, Mr. Park.
Thank you very much.